This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about cancellations and why actual notice of a cancellation is effective, especially when the insured cashes the refund check as evidence that they in fact received actual notice of the cancellation. The Supreme Court of North Carolina considered whether Nationwide effectively canceled plaintiffs' fire insurance policy before their house burned down. Almost 2 months before that tragic fire, Nationwide mailed plaintiffs a letter explaining when and why it was terminating their coverage. The cancellation date came and went, and afterwards Nationwide sent plaintiffs a check listing their policy number and refunding the excess premium. In Nung and Nhiem Tran versus Nationwide General Insurance Company, the Supreme Court of North Carolina on August 23, 2024, dealt with the plaintiff's contention that the trial court was wrong when it found that they saw the cancellation letter, but they received, signed, and cashed the refund check over a month before the fire and had no excuse for not noticing why they cashed that check. Plaintiffs have 1 daughter and 3 sons, and in 2010, plaintiffs moved into a house in Wake Forest, Carolina. On 1 April 2015, nothing to do with April Fool's Day, Mr. Tran filled out an online insurance application after an AAA insurance policy was canceled. Mr. Tran arranged for Nationwide to withdraw monthly premiums from his checking account, and he later logged into Nationwide's web portal and signed the policy electronically. Nationwide issued that policy subject to an underwriter's review. Nationwide eventually dispatched an underwriter to inspect plaintiff's property, and the inspection unearthed many of the same hazards logged by the previous insurer, AAA: rotten siding, an unfenced swimming pool, and an unsecured trampoline. The latter 2 conditions were classified as gross hazards. Citing these concerns, Nationwide, like AAA, chose to cancel plaintiff's policy. The company then mailed plaintiffs a notice of cancellation on 22 May 2015 by first-class mail. The letter listed the 3 hazards prompting the cancellation. It also explained that plaintiff's policy would end on 6 June 2015 unless they fixed the identified risks. Plaintiff did not contact Nationwide nor respond to the cancellation notice, and so the company terminated their policy on 6 June 2015, 15 days after mailing the cancellation letter. According to plaintiffs, they never received the letter. However, everyone agreed that after Nationwide ended plaintiff's coverage, it stopped withdrawing monthly premium payments from their bank account, and while funds were withdrawn at the beginning of April, May, and June, plaintiffs did not pay for insurance in July. 2 days after the cancellation date, Nationwide mailed plaintiffs a check refunding the excess premium paid for June. The check prominently listed the policy number. Plaintiff endorsed and cashed that check on 17 June 2015. On the evening of 24 July 2015, plaintiffs were at church when their home caught fire. The entire structure burned down, consuming the family's belongings. Plaintiffs later filed a claim with Nationwide, but the company rejected it, contending that plaintiff's insurance expired before the fire. The Supreme Court, analyzing the issue, noted that insurance companies may cancel insurance policies by, quote, giving to the insured a 5 days written notice of cancellation with or without tender of the excess of paid premium above the pro rata premium for the expired time which excess, if not tendered, shall be refunded on demand. Notice of cancellation shall state that said excess premium, if not tendered, will be refunded on demand." Close quote. As the Supreme Court explained almost a century ago, statutory notice requirements are manifestly for the protection of the insured. Mindful that the General Assembly designed notice provisions to give insureds a meaningful chance to avoid coverage lapses, the Supreme Court explained that the manner in which notice is given is of secondary importance. It is the fact of notice that matters. In general terms, a person has actual notice when the information given directly to the insured imparts clear knowledge of a fact or condition with legal significance. Because Nationwide gave plaintiffs the timely forewarning required by statute, it properly canceled the policy. Though plaintiffs deny receiving Nationwide's cancellation letter, they were armed with clear knowledge and advanced warning of their policy's termination. Plaintiffs had actual notice of cancellation, and Nationwide duly ended their insurance before the fire. The Supreme Court found actual notice of cancellation because 2 days after the policy was terminated, Nationwide sent plaintiffs a check refunding the excess premium. Plaintiffs not only received that check, but personally signed and cashed it. The check clearly listed plaintiff's policy number, and the amount of the refund equaled the June premium less the window of coverage until the cancellation date on 6 June 2015. Continuing to focus on substance over form, the Supreme Court held that the plaintiffs had advance warning of cancellation and were armed with the information necessary for their protection. Because the manner in which notice is given is of secondary importance when clear evidence showed an insured's actual notice, the analysis began and ended with plaintiffs' direct and palpable knowledge of the policy's expiration. Because Nationwide canceled plaintiffs' coverage well before 24 July 2015, the Supreme Court concluded that their policy was not in place at the time of the fire. In my opinion, the plaintiffs had been canceled by AAA for the poor and dangerous condition of their property. They did nothing to change that condition and applied for insurance from Nationwide. Nationwide inspected the property and found the same defects that prompted AAA to cancel and did the same. They should have known beforehand, but they were not so told by the plaintiffs, even if the insureds failed to see the cancellation notices they claimed. By cashing the refund check, they proved that they had actual notice of the cancellation. If they did not tell Nationwide about the reasons for AAA's cancellation, they had 3 months of insurance until Nationwide inspected the property and canceled. Unfortunately for the plaintiffs, their house burned down after the cancellation was effected. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,850 blog postings. You can also subscribe to the videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble and the like button on YouTube. And please tell your friends and colleagues about the blog and the videos and let them also subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.